This video is for educational purposes and does not constitute legal or tax advice. Here's a question most Florida families never ask until it's too late. What actually happens to everything you've built? Your home, your investments, your business. If you die without a will, the answer might surprise you. And if you have significant assets in Florida, the stakes are much higher than most people realize. I'm going to walk you through exactly what Florida law says, what happens if you do nothing, and what the smartest families are doing to protect their wealth and their loved ones. To start, it is important to understand that property generally passes in one of three ways. First is contractual, such as a beneficiary designation or assets titled in a trust. Second is by operation of law. An example is joint tenants with right of survivorship. Finally is the law of probate, where a person either has a will or does not have a will. By the way, having a will does not mean you avoid probate only if property falls into the first or second category. Does it pass outside of probate? Stay with me, because by the end of this video, you'll know exactly what you need to do next. Let's start with the worst case scenario. You die without a will in Florida. What happens? Florida has a set of laws called the intestacy statutes. These are essentially the state's default rules for distributing your assets when you haven't left instructions of your own. And here's the thing, the state doesn't know your family. It doesn't know your wishes. It doesn't know that you wanted your beach house to go to your daughter, or that you specifically did not want your estranged brother to receive anything. Florida's intestacy rules follow a formula, and that formula may have nothing to do with what you actually wanted. Here's how it generally works. If you're married with children, and all children are from that marriage, your spouse typically inherits everything. But if you have children from a prior relationship, your spouse may only receive half of your estate. Your children from that prior relationship receive the other half. That can create serious conflict and serious financial strain for a blended family. And if you have no spouse and no children, Florida looks to your parents, then your siblings, then further relatives. The state will work its way down the family tree until it finds someone. In rare cases where no relatives can be found, your estate cheats, meaning it goes to the state of Florida entirely. This is why a will is not just a document. It's a declaration of your intentions. And without one, you've handed that decision to a legislature that has never met you. So what does a will actually do for you? A will, formally called a last will and testament, is a legal document that tells Florida courts exactly how you want your assets distributed after your death. But it does more than just divide up property. A well-drafted will accomplishes several important things. First, it names your beneficiaries. You decide who gets what, not the state. Second, it names an executor, called a personal representative in Florida. This is the person responsible for carrying out your wishes, paying your debts, and managing the distribution of your estate. For high net worth families, choosing the right personal representative is critical. Third, and this is one people often overlook, it names a guardian for minor children. If you have kids under 18, a will is the only place you can formally designate who raises them if something happens to you. Ultimately, the judge will decide what is the best interest for your children but this declaration from you carries a lot of weight in the judge's decision. Fourth, it can include specific bequests. Want a particular piece of art to go to a specific child? A vacation home to your grandchildren? You can spell that out precisely. And fifth, it can set the foundation for more advanced planning, including trusts, which we'll talk about in just a moment. Now here's something important for high net worth families to understand. A will alone is often not enough. Here's what most people don't realize about wills. Even if you have a perfectly drafted will, your estate still has to go through probate in Florida if the property does not, for example, have a beneficiary designation or is titled in a trust. Probate is the court-supervised process of validating your will and overseeing the distribution of your assets. And in Florida, it can be slow, expensive, and very public. Florida probate can take anywhere from 6 months to 2 or more years, depending on the size and complexity of your estate. Attorneys' fees and court costs can consume a meaningful percentage of your estate's value. And because probate is a court proceeding, it becomes part of the public record, meaning anyone can look up what you owned and who received it. For a high net worth family, that's not just inconvenient, it's a privacy risk. This is why many people use a will as just one piece of a broader estate plan, paired with revocable living trusts, beneficiary designations, and other tools that allow assets to pass outside of probate entirely. We'll cover those strategies in detail in future videos. Make sure you're subscribed and hit the notification button so you don't miss them. Florida has some unique rules that every resident should understand, especially if you own significant real estate. Florida's homestead laws are among the strongest in the country. Your primary residence is protected from most creditors, which is a powerful asset protection tool. But homestead also creates restrictions on how you can leave your home in a will. If you're married, you generally cannot leave your homestead to anyone other than your spouse without their consent. Even if your will says otherwise, Florida law can override it. And if you have minor children, there are additional restrictions on transferring homestead property. These rules exist to protect families, but they can create complications if your estate plan isn't designed with them in mind. Florida also has what's called an elective share law. This means a surviving spouse has the right to claim 30% of your elective estate, regardless of what your will says. A typical prenup or postnup may waive this right. This is designed to prevent a spouse from being completely disinherited, but it can also affect complex estate plans if not properly structured. In Florida, a valid will must be signed in the presence of 2 witnesses and a notary. Electronic wills are now permitted under Florida law, but they have their own specific requirements. A will that doesn't meet these formalities is invalid, which means Florida's intestacy rules kick in, as if you had no will at all. So, where does this leave you? If you're a Florida resident with significant assets, whether that's real estate, a business, an investment portfolio, or all of the above, here's what a comprehensive plan typically looks like. Even if you go on to build a more sophisticated plan, a will is your foundation. It covers assets that may fall outside of trust or beneficiary designations, and it names your executor and guardian for minor children. For most high net worth Florida families, a revocable living trust is the centerpiece of the estate plan. Assets held in the trust pass directly to your beneficiaries. No probate, no public record, no court involvement. It also gives you complete control during your lifetime. Your retirement accounts, life insurance policies, and certain bank accounts pass by beneficiary designation completely outside your will. If those designations are outdated or incorrect, your carefully drafted will cannot override them. Depending on your estate size, you may benefit from irrevocable trusts, family limited partnerships, charitable vehicles, or gifting strategies designed to reduce estate tax exposure. These are the tools we'll be exploring in depth on this channel in future videos. Florida's laws are specific. Generic online wills and national legal platforms are not designed for Florida's homestead rules, elective share provisions, or the complexities that come with significant wealth. Get qualified, Florida-specific advice. So, do you need a will in Florida? Absolutely. But more importantly, you need a plan. eWill is your starting point. But for high net worth families, it's rarely the finish line. The families who protect and grow generational wealth are the ones who take a comprehensive, proactive approach to estate planning, not a reactive one. If you found this video helpful, please subscribe to the channel. Every week, I'll be breaking down complex Florida tax and estate strategies in plain language, designed specifically for families like yours. And if you found this useful, share it with a family member. Estate planning is a conversation that's better had early and together. I'll see you in the next video.